The objective of Real Estate Regulation and Development Act 2016, which came into force in May 2017. Before I go into what is the RERA Act, I would like to know anybody in the audience is aggrieved by any of the builder. Now, coming to the why there was a need, there was already one MOFA was there, then consumer forum was there, means as per the pecuniary jurisdiction, either you can approach the district forum, state commission or NCDRC. Was there a need? Now, have you heard about the SEBI? The SEBI role is to, regulate the stock market. There were a lot of manipulations which were going on. Insider trading was going on. And, the public at large, who were facing this problem, and they used to buy penny stocks at a high rate. And the moment, they buy the share, the next day it starts going down. And there was a huge loss, which was incurred by the majority of the investors. In stock market, it is said that 98% of the investors or people who invest money are losers. Only 2% of the people make money. In real estate, what was happening is there was of the carpet area, right? The builder used to sell the same flat of 500 square feet as per the MCGM, that is what we call in Mumbai, that is Municipal Corporation of Greater Mumbai. That same 500 square feet of flat was sold at 1000 square feet. So the area was inflated, right? And then builder used to take money and, he used to divert the fund and put it into other projects, or used to, live a lavish lifestyle, buying luxurious car, BMW, Mercedes, red Cadillac, and so on. And he was not able to complete the project on time. And the home buyers were facing a lot of problems. And if the RERA was not there, and if the consumer forum, you don't approach, because many advocates don't advise and people are not aware about it. So they used to go to High Court for a specific performance. In Mumbai, any flat is going to cost between 1.5 crore to 2 crore rupees. So if that value is considered for specific performance, then you have to pay around 3 lakh rupees as a court fee. And the similar amount the advocate is going to charge. Now, in the first hearing, the builder brings a very high profile counsel. So your advocate will advise that, if you want to fight a case, we'll also have to engage and counsel. So the counsel fees will start from 30,000 to 1 lakh, 50,000 per appearance, right? And there are counsels in Mumbai who charge per appearance for 10 lakhs, 15 lakhs and 20 lakhs. So for a common home buyer, it was not, financially viable to challenge the builder in the High Court. The RERA came to regularize everything. So now if you are thinking of buying a flat, so what you can do is go to the RERA website, put the project name or the project registration number, and you will get all the details. Initially, the builder has, used to suppress the fact. He will never share the sale deed, that sale agreement with you. And you were only able to see the sale agreement at the time of registration. And it was in such a hurry that he will tell you, sign here, and he'll make you sit in front of the camera. Your photograph is clicked, your thumb impressions are taken, and the agreement is gone for registration. But you don't know what is the content of it. I myself have fought many cases where, the agreement was registered, but the possession date was kept blank. Right. So there are n number of judgments in NCDRC court as well as in the Supreme Court, which was upheld that if you have taken more than 20% of the money from the home buyer, then 3 years is a reasonable time to complete the project. That is held by Supreme Court also, right? So now you have to wait till Supreme Court. So RERA has come so that you can see, if you open the website of that builder, you can see what is the date of possession mentioned in the RERA, and he can get maximum 1 year extension. So that is now clear that what is the date of possession, because it is mentioned in the RERA website. Secondly, there will be a draft agreement which will be there on the RERA website. You can go through the draft. You know, if there are any objectionable clause which is not as per the RERA, you can take the objection. And thirdly, he will share all the information regarding that project, how many story project is there, when did he got the IOD, and how many floors CC he has got, right? And when he will get the occupation certificate. So everything has become very transparent and accountable. Now you have the choice to select from which is the best builder, right? That is also possible if there are litigation pending, because if there are any litigation pending, the builder has to upload that on the RERA website and show that this litigation are still there, and he cannot hide, suppress the fact. Initially, all these things were not in the public domain, and the home buyer was not aware of it, that there is a litigation going on, and there is the CC is not there. So now you know that CC is up to 15th floor. So I don't have to book a 16th floor flat, because in Goregaon, there are 2-3 builders who have sold 44 floors, whereas the building had only 34 floors, highest CC. And beyond that, the CC was not available because there was a restriction from the airport authority, and his FSI was also consumed up to 34 floor. But still the builder had sold 44 floor flat and registered the agreement. So now with this information all available on the public domain, so there is less chance of home buyer getting cheated. Now, this was the main idea. And one more point was that the justice should be affordable and it should be quick. Initially in RERA, we used to get, judgment within 14 days, then 1 month, then 2 months. Now it is taking more time, but still some accountability and transparency has come. The home buyer is not kept in the dark. No facts are being suppressed. And if the facts are being suppressed, then if you can produce that evidence, then the builder can also be penalized. Now we'll go to the 5-fold object of the RERA. To establish the real estate regulatory authority, promotion of real estate sector. Why there is a need of real estate sector to be promoted in a regularized manner like the SEBI is doing? Because this is only the one sector which is feeding another 200 industries. If you calculate right from the excavation level, so what you require is a JCP, right? So the JCP demand is increased. Then what you need in the foundation, steel, iron rods, the steel demand is increased. Then cement, and then if you name up to the top floor, plumbing pipes, tiles, bathroom tiles, hall tiles, then doors, windows, glass, electrical conduits, electrical wire, electrical switches, electrical fittings, fans, everything, plywood industry, all industries are fed by this real estate project. If this project goes well, then all industries, they will get more and more work orders. So that is very essential that we have to promote this sector so that the other industries also, get benefited from this. To ensure sale of real estate project in an efficient and transparent manner, to protect the interest of consumers in real estate sector, to establish an educating mechanism for speedy dispute redressal. Now, this is very important, that speedy redressal has to be happen. It should not take years and years and decades and decades. You know how our judicial system is overburdened with so many cases. So this is one way to bring that the aggrieved home buyer gets a quick and affordable justice. Crucial provisions under RERA 2016. Provisions regarding the following: promoters, real estate agents, they also come, even the real estate agent who are selling under construction flat, they have to get registered themselves in the RERA, then only they can sell it. Then allottees, that is consumer home buyers, authorities, and miscellaneous. Promoters, dear Mr. Promoter, say hi to the new key to your treasure box. Why this is a treasure box? Because if they don't register, they cannot sell the flats. It's a crime. And this is the Maharashtra government website of RERA. You can make a note of it. Now, Section 3. No promoter shall advertise, market, book, or sell, or offer to sell, or invite people to purchase in any manner any plot, apartment, or building in any real estate project in any planning area without registering the real estate project with the Real Estate Regulatory Authority. Section 59. Penalty of 10% of the estimated cost of project. Violations continues, the promoter shall be punishable with imprisonment which may extend up to 3 years, fine which may extend to further 10% of the estimated cost of project, or it can be both, jail also. But in the last 4 years or 5 years, I have not seen that this section has been implemented by the RERA authority, not in Mumbai, but Maharashtra, but anywhere in India. Validity of the registration till the date of completion as stated by the promoter. So validity is, suppose today if I am a builder and if I am registering and I say that by 2026, I will give the possession. So my validity will be up to 2026, and plus if I'm not able to complete the project, I'll get 1 more year extension. So that is one thing. And extension of registration. Registration may be extended due to circumstances beyond control of the promoter, force majeure, namely flood, drought, fire, cyclone, earthquake, or other natural calamities. Now, during pandemic, this extension was given to all the builders. Exemptions from registration. Now, you don't have to register all the projects if the area of the land proposed to be developed does not exceed 500 square meters. Number of apartments proposed to be developed does not exceed 8, inclusive of all phases. Now, suppose if I am constructing a building which has only 8 flats, so I don't have to register that project. And where the promoter has received completion certificate prior to 1st May 2017. If the promoter has received an occupation certificate before the 1st May 2017, then he doesn't have to register. Ongoing project, that is to register prior to 1st August 2017. So any ongoing project, if they have started in 2010, but they have not completed till date, so they have to register. Projects for the 3 Rs, not involving marketing, advertising, selling, or allotment. Now, if there is a redevelopment and there is no sale component, or there is a restoration of the building or the repair of the building, so they don't need to be registered. Mr. Promoter, let's spit it all out. Disclosures in application section 4 subsection 2. Details of project launched in past 5 years. Now, if you go to any of the RERA website, you will see there are ethical builders who do business in ethical way, and they are a good builder. So they will give you all the details of their previous project which they have completed. But there are many builders whose projects, there are 5 to 10 projects, but they are stalled. So they will say this is a new project under a new company's name. So you have to be very careful while selecting a builder that the past track record is good. If the builder has delayed a possession, say by 6 months to 1 year, that is tolerable. But if the projects you see are stalled and many litigations are there, so you should avoid such type of builders. Authenticated copies of approvals and commencement certificate. This is very important because initially builder used to sell the flats without getting any approval from the authorities. Now you know that I am going to buy this flat and the authority has given or issued a commencement certificate, and the CC is up to 5 floor, 10 floor, 15 floor. So it is safe that I book the flat which is within the under the sanctioned floors and not above the sanctioned floor. Then sanction plans, layouts, proposed facilities, number and areas of garage for sale. Where promoter is not the owner, agreement entered into between the promoter and such owner. FSI TDI entitlements which are proposed to be utilized, aggregate area in square meters of recreation, open spaces, and all the covered parking spaces. He has to swear about the legal. There are no encumbrances. If there are legal cases are pending, title cases are pending, that on the website. So you take an informed decision. And most importantly, the date of completion, that is date of possession. Initially, even in the registered agreement, that was used to be kept and the date of possession was not mentioned. So, the amount collected from the allottees to be deposited in schedule bank to cover the cost of construction. Now, suppose you pay to the builder, say an installment of 1 lakh rupees. So 70,000 rupees he has to keep it in the escrow account and use it in the construction of that project. Only 30% he can use it for administration purpose, to salaries, to maintain the office and all. Initially, what used to happen, we never knew what he's doing with our 1 lakh rupees which we are giving. Either he's putting to constructing in the same project or he's diverting the fund. And section 16, penalty up to 5% of the estimate cost of project. If he violates anything, then there is a 5% penalty. Section 7, revocation of registration. Authority may revoke a registration on being satisfied that the promoter makes default in doing anything required under the Act, rule, and regulations. The promoter violates terms and conditions of promoter is involved in unfair and fraudulent practices and irregularities. Once you can see, no access to its website. His website will be blocked of that builder. Name of the promoter to appear on list of defaulters on the website. That can be done throughout India also. Deregistration communicated to the authority in other states. Means throughout India, it will be flashed that this builder is been blacklisted. Freezing of bank account with the schedule bank. What is the status of the project post revocation of registration? Section 8. Functions and duties of promoter. Section 11. Website during booking and issue of allotment letter and others. Create a web page. Enter details as stated in section 4, subsection 2, and quarterly updates on project. And every 3 months, he has to update what is the status of that project, whether he has completed as per the timeline given or if there is any lacking. So he has to keep on updating. If he has sold any units, he will say, now in this quarter, I have sold so many units. So everything is transparent. And disclose advertisement and prospects. So nothing can be hidden now from the home buyer. During booking and issue of allotment letter, disclose sanction plans, layout plans approved by the competent authority. That is the right of allottee to see whether all the sanction plans are being shown to him, not the sale plan. What they show you when you go to the builder's office, they show you one plan. That is a floor plan, that is a sale plan, not the sanction plan. So whenever you go for a booking of the flat, you insist on that I want to see the sanction plan. So once you see that sanction plan and then compare it with the sale floor plan, then you will understand where is the gap. And then you are very sure now this project has a sanction. Disclose stage-wise schedule of completion of the project, including the provisions of civic infrastructure like water, sanitation, electricity. This is the right of allottee. Fulfill obligations and functions as states in the Act, rules, regulations, and agreement for sale. Obtain completion certificate and occupation certificate. Obtain lease certificate where the real estate project is developed on a leased land. Form a legal entity like association, society, or cooperative society within 3 months from the date on which 51% of total number of the units are allotted in the building and have booked in their apartment. So now this is a very important clause. If the builder has sold, even he has issued allotment letter, the moment he reaches 51% of the units which he has booked, he has to within 3 months make a cooperative society or an association. So this is very important. Pay all outgoings collected from the allottees till physical possession is transferred. Not to mortgage or create any charge on the property after execution of the agreement of sale. Now, what was happening initially, the builder used to sell the flat to you, but he used to mortgage the same flat to the bank and take a loan on it, right? So now this thing will not happen because it is very well clear that after he enters into a sale deed, he cannot mortgage your flat with any bank for taking loan. Cancel allotment only on terms of agreement for sale. Section 12, Loss sustained due to incorrect or false statement in advertisement or prospectus. If builder gives you any false information that he's going to give you a swimming pool, he's going to give you a clubhouse, or he's going to give 4 lifts, but then when you take the possession or when you see that the builder is not given 4 lifts, he has given only 3 lifts, there is no swimming pool, there is no clubhouse. So we can take action against, because we were misled due to the advertisement or the prospectus or the sale brochure which has shown that I will provide you so many amenities, but in the end we are not getting the same amenities. So section 12 will come into your help. Section 13, no agreement for sale, no advance deposit. So the moment you pay more than 10%, suppose the flat value is of 1 crore rupees, you pay 10 lakh rupees, and builder is demanding another 1 lakh rupees. So you have to pay only that 1 lakh rupees when he enters into a sale agreement. So anything about 10% which is given to the developer should have a registered agreement. You cannot just pay him on the allotment letter. Section 14, adherence to sanction plan. He cannot change the plan. The promoter squad cannot act without the consumer's nod. Now, because see, when I had gone to book the flat in the sales office of the builder, I had shown one plan. Now, the builder becomes greedy and he wants to change the plan or whatever is there. He cannot change the plan until and unless he takes the consent of the majority of the allottees. So this is the power now the RERA has given to the allottees, the right of allottees. Allottees specify and promoters has to rectify. Section 15, obligation of promoter in case of transfer of a real estate project to a third party. So if, sometimes the builder is in a financial crunch and he has to sell the project or he has to take a third party into it, enter into JVC, but all that has to be done with the consent of the allottees. He cannot do suo moto. Section 16, insurance of real estate project. He has to see that the real estate project is properly insured. Transfer of title, conveyance, and common area. So he has to transfer the moment he gets the occupation certificate. Within 3 to 6 months, he has to transfer the title of that land to the society, to the conveyance, and all the common areas also should be handed over to the society. Section 18, promise broken. Let money apologize. This is right of allottee. Interest plus compensation or interest. So section 18 is a very powerful section of the RERA, which comes handy for every home buyer. If the builder has delayed the possession, the allottee has the entitled to get the interest for the delayed period, and plus he can demand for the compensation. Section 61, contravention of any provision except section 3 and section 4 or the rules and regulation made, penalty is up to 5% of the estimated cost of project. But till date, I think 1 or 2 builders have been, penalized in Maharashtra. We want, to this section to be exercised more by the authority so that there is a discipline in the builders. They don't take lightly the RERA Act. Agents, let's know who you are. So section 9 says the agents have to register themselves with the RERA, then only they can sell the sale component. No real estate agent shall facilitate sale or purchase of any plot, apartment, or building in real estate project registered under section 3 without obtaining registration. Documents accompanying application, recent photograph, income tax return of last 3 financial years, proof of address of principal place of business, telephone numbers, etc., details of civil and criminal case pending. Validity of registration. The registration to be valid for a period of 5 years for estate agent. This is registration number to be quoted on every sale facilitated by the agent. Bar on registration. No fresh application shall be accepted for a period of 6 months from the date of revocation or suspension of the registration. Functions of real estate agents. Not facilitate the sale or purchase of any plot, apartment, or building in any real estate project not registered with the authority. So he cannot sell any flat which is not registered with the RERA. So that is the beauty. He can only sell if the project is registered under RERA. maintain and preserve prescribed books of account and documents as prescribed, facilitate the possession of all the information. Section 62, penalty up to 5% of the cost of plot, apartment, building, or which the sale or purchase has been facilitated. Now, suppose you purchase a flat of say 2 crore rupees, and builder or the estate agent has done or misguided you or given you wrong information or sold you by misleading information, then there is a possibility if you complain in the RERA, he can be penalized up to 10 lakh rupees as a penalty, up to 10 lakh rupees. The other side of the coin, allottees, you are also not exempted. Duties of allottees, section 19, payment to be made as per the manner and time fixed in the agreement for sale. So if there is a milestone mentioned that on the second slab, you will have to pay the first installment. On the fourth slab, you will have to pay the second installment. On the sixth slab, you will have to pay the third installment. And if you delay, then you have to pay the interest. Delay in payment of above charges will attract payment of interest. Take physical possession within 2 months of the issuance of the occupancy certificate. The moment the builder writes a letter to you and sends a copy of occupation certificate, within 2 months, you have to make arrangement to take the possession and make the balance payment and take the possession. Participate towards formation of legal entities, that is society, association of allottees or cooperative society, etc. So whenever the more than 51% of the units are booked and the builder calls you for forming an association of allottees or society, you have to cooperate. So this is your obligation too. Authorities under RERA, Real Estate Regulatory Authority. Composition, 1 chairperson and minimum 2 whole-time members. Filing of complaints may be filed by the aggrieved person under Section 31 of the Act for violation of the Act, rules or regulation. Manner of implementation of orders in the same manner as if it were a decree or order made by the principal civil court or original jurisdiction in a suit, or send the order to the principal civil court for address of hearing of complaints. Maharashtra, see now this has been changed. Now normally in RERA now we are doing online hearing only. And if suppose if the physical hearing starts, so there is 2 bench sitting in Churchgate and 1 or 2 bench are sitting in BKC. So this address has changed. Period of disposal, that is section 29, within 60 days from the date of receipt of the application, which was happening initially, but right now it is taking time, and due to pandemic, it is taking much more time. It is taking almost the same time which Consumer Forum or State Commission has to take it. So now it is parallel now. So if you now there recently, there are good orders from the RERA authority also. One of the order which we got, I'm going to share it with you. But in the past 6 months, I was not happy with the RERA, how they were dealing it. They were delaying the hearings and the orders were not, clear cut in favor of the home buyers, and, they were treating towards the builder. So I used to file all my complaints in Consumer Forum or State Commission instead of going to the RERA. But 1 or 2 orders which the RERA has changed again the perspective that they are doing a good job. Stages of inquiry after filing the complaint. Appearance of the party, recording of the plea of respondent. If he pleads guilty, then order. If not plead guilty, then the explanation reply to be fixed by the respondent. Reading the evidence, oral or documentary, final arguments, and final order. So there are 5 stages. And, if within 6 months, it should be handed, this complaint should be disposed of, but it is not happening. So we will push. We'll take up this matter with the government of Maharashtra and Union Home Minister, that there has to be some mechanism where the allottees or the aggrieved home buyer gets a quick justice. It should not be happening like other regular court. Otherwise, the essence of bringing RERA is not met. Consequence of breach of order. Promoter, that is section 3, penalty up to 5% of estimate cost of project. Agent also, it is estimate cost of the unit, building, plot or apartment, whatever he sells. Allottee, Section 67, penalty up to 5% of the estimate cost of the building plot or amount. So even the allottees, if they do something wrong, they can also be penalized up to 5% of the cost of that building plot or apartment what they have booked. The Real Estate Appellate Tribunal, the composition, one chairperson, minimum 2 whole-time members, one being a judicial member and the other technical administrative member. Jurisdiction, try appeals from the order of the Real Estate Regulatory Authority. Period of limitation, within 16 days from the date on which the copy of order is received. So if you are aggrieved or the builder is aggrieved, so they can approach the RERA Appellate Tribunal at Kalagoda in Mumbai for the Maharashtra, but within 60 days from the certified copy of the order is received. Manner of implementation of the orders. Order to be executed by the Appellate Tribunal in a decree of a civil court. Appeal to High Court within 60 days from the date of communication of the order of the Appellate Tribunal. So if you are not happy with the order of the Appellate Tribunal, you have a 60 days window to challenge that order in appeal into the High Court. That is called a second appeal. Consequence of breach of order. Promoter Section 64, imprisonment maximum 3 years or fine up to 10% of the estimate cost of project or both. Real estate agent, Section 66, imprisonment of maximum 1 year, fine up to 10% of the estimate cost of the plot, apartment, building for which the sale or the purchase or both. Allottees, imprisonment maximum 1 year, fine up to 10% of the estimated cost of building, plot, apartment or both. Miscellaneous, this is very important. Bar of jurisdiction, Section 79, civil courts have no jurisdiction. Now, suppose you are aggrieved home buyer, and you go to the High Court. High Court will say that Section 79 of the RERA clearly says that the High Court doesn't have the jurisdiction. So first, you have to file your complaint in RERA. If you are not happy with the RERA, you challenge that in the Appellate Tribunal, and after that, you come to the High Court, right? And if you're not happy in the High Court, then the Supreme Court. So if, in consumer forum, if I suppose my claim is about more than 50 lakhs and under 2 crore, then I can go to the State Commission. From State Commission, the order will be challenged to NCDRC and from NCDRC to the Supreme Court. And if my claim amount is more than 2 crores, then in consumer forum, I file my complaint in NCDRC and that can be challenged only in the Supreme Court. So you have to be very, very, smart in deciding whether I should approach RERA or whether I should approach consumer forum. If your stakes are high and more than 2 crores, then I would prefer that you file your complaint in NCDRC because then there is only one authority left, that is Supreme Court. And I have seen that in most of the cases, whatever the orders of the NCDRC are there, they are upheld by the Supreme Court. Yesterday, 2 days back also, Supreme Court has given a very wonderful order and upheld the order of the NCDRC that you can see on my blog, Wake Up India Designer blogspot.in. Then cognizance of offense, Section 80. No court shall take cognizance of any offense punishable under this act. Rate of interest payable if the promoter and the allottee. See now what was happening. This is a very important point we should note down. That builder used to write in his agreement that if the allottee fails, I will charge him 18% of interest or I will charge him 24% of interest. But RERA has said nothing. Whatever anyone defaults, whether it is a promoter or the allottee, there is a formula. Whatever the State Bank of India lending rate is there on that day, plus 2%. Suppose if today the lending rate is 7%, then 7 plus 2, I will get 9%. That is the 9%. If allottee fails, then he has to pay 9%. And if builder fails, defaults, he has to pay 9%. So the law is very clear. There is no disparity that for the allottee, the interest rate is separate, and for the home buyer, the interest rate is, the builder rate is separate. So now it has given a very clear-cut formula that how the rate of interest will be calculated. Timeline for refund within 30 days from the date on which such refund becomes due and payable to the allottee. Parking space, open parking area. There are many confusion. Even today, I get lots of WhatsApp and messages and emails and phone calls. So this is a very clear cut that this has been clearly included in the definition of common areas, which need to be conveyed to the association of allottees or the cooperative housing after the occupancy certificate is received. Hence, sale of or allotment of open parking area by the promoter is not permissible. So that becomes the common area. Open to sky parking area is the society's common area, and the society has the discretionary power, and they can allot the parking through lottery or whatever they feel like, or if everybody is having the same number of parking, so it can be numbered that way also. So but it is very clear that builder cannot allot or sell the open parking space which is open to sky. Covered parking, as defined in the Maharashtra Real Estate Regulation and Development Registration of Real Estate Projects, registration of the real estate agents, rates of interest and disclosures on website rule 2017 is permitted to be sold. So any garage or a covered parking which is approved by the corporation can be sold. The garage as defined in the Act is permitted to be sold. Thank you. I am ready to take the question answer session.
Yes, I had a query. What is the role of RERA in a housing society redevelopment project when the development is taking place by appointment of developer and he can sell the surplus area?
In the redevelopment, the existing member don't have any remedy available in the RERA because you don't come under the definition of allottee. Only the sale component will come under the definition of allottee and they can approach RERA. For you, you will have to approach High Court for the specific performance.
Sir, you mentioned in your PPT that the remedy period under RERA is 60 days from the date of application.
So that's what I told you, that initially the orders were passed within, the first order was passed within 14 days. Then it took months, then 2 months, 6 months, and now it is taking years, 2 years, 3 years. So it is taking almost the same time the consumer forum, district forum, or the state commission is taking. So depending upon your stake and pecuniary jurisdiction, if you are an advocate, you have to advise your client when to approach RERA and when to approach the consumer forum. So you can see my videos on consumer forum also, consumer courts. So you will get a fair idea. I have compared both RERA as well as the consumer court.
What is the remedy available to the home buyer if the sale deed document which is registered at the sub-register office is different from the sample sale deed document which is uploaded by the builder in his disclosure on the RERA website? Yeah, he has to, that's what I told now, if he has suppressed the fact. See, first thing is, when was this agreement signed? Yeah, after the RERA came into force. So that means you can file a complaint against the builder. Okay, because normally what I have seen is the builders now, what they do is they just upload a sample document and the actual document which is executed is different from the sample document. Yeah. Now, this is whose mistake? But the buyer, say for example, as you said, that he is rushed to the sub-register office and he that was happening prior to RERA. Right now, you have the copy, right, which is uploaded on the RERA website. You download it, and when he says, you tell him that you send me a draft copy, because see now what happens. Initially, you will pay 10% to him and get an allotment letter. Yes. So you become the allottee. You come into the definition of RERA. Yes. Yes. Officially write an email to the builder that send a draft copy of the agreement for me to vet, and get it vet through an advocate. If you are an advocate, you can vet or compare it. And if it is not the same, immediately complain it to the RERA, because you have an allotment letter and you are having this right to complain. Okay. Thank you, sir. It's that simple. See, you cannot sign it. Initially, he was telling you, "Aap register office mein aa jao." But after coming into RERA, he cannot suppress the facts. And if he has suppressed the facts, that matter you can bring to the RERA, that what is uploaded on the RERA website and what he is giving me to sign is totally different. Yes. Sir, my second question is, when a
Yeah.
builder accepts up to say 20% payment from the buyer, whether the builder will execute agreement for sale or a sale deed document. Are the rights of the buyer diluted if the builder executes agreement for sale instead of a sale deed?
My question is why the home buyer will pay 20% when the provision says that anything 1 rupee about 10%, the builder registered sale deed.
Okay, so he has to register sale deed only, not the agreement for
Absolutely.
sale.
See, you see, you now this the video is available and there are so many things available on the net. That is your right of an allottee, right? Why you will sell? That means if you are knowingly settling for something less, that means something is wrong with you. Law says that even if he's asking 1 rupee about 10%, it has to be a registered. And you should have gone for a sale agreement.
Okay, so it is the sale agreement and not the agreement for sale.
No,
After,
not agreement for sale.
So my next question is, can the builder take consent from the home buyer at the time of registering the agreement or sale or the sale deed, as you said? Does the
What-
home buyer has any remedy if the
What
builder
consent?
changes
What?
the plan? See, the
No, but
consent
why he
that
has to sign? But tell me, when such a powerful tool of RERA is given to you, right? For anything which is not as per the provision of the law, if he's asking the consent, you can refuse it. You can approach the RERA. See, first
okay,
is you have to take an allotment letter. You become the allottee, yeah, as per the definition of RERA. Then,
yes,
if builder is doing any mischief, do a correspondence. Tell him to send me a mail.
okay,
Sends you a mail. Then he says, "No, you have to give a consent." Then you ask him, where is the provision in the RERA that I have to give a blank consent for knowing the content of it?
which eventually means that the home buyer has to recheck himself that whatever is
Yes.
mentioned in the
Tell him that I am not going to give you any consent. That's it. And you can take up this
Okay.
in the RERA.
Okay. So he has to be very much vigilant when he goes to.
He has to see when you go to buy any grocery store or you say any vegetable vendor, you bargain.
Yes.
Why you are negligent when you are buying, when you are parting your hard-earned money to the builder?
Yes.
Why you should not be vigilant?
Yes, absolutely. Because sir, sometimes what happens, the innocent home buyer, maybe they might sign the consent letter without knowing that they are
No, see,
actually signing it.
we cannot say innocent home buyer when everything is available, the RERA awareness is available, and he knows he's right, and then also he does something wrong. So RERA cannot be held responsible for it.
Yeah, so the best option
Exercise
probably
is
would
right.
be best option.
He has to put his foot down, take a legal remedy, go for take a professional advice.
Yeah, maybe he can take some legal advisor with him to make sure that he is not signing anything else beyond the sale
Yes,
deed.
absolutely. And do everything correspondence, either email or through a notice or registered AD.
Can we go for RERA proceeding as well as consumer court proceeding at the same time? Or is there bar?
Either you go with RERA or you go with the consumer court. You cannot have both the proceedings at the same time, but you can have one civil and one criminal proceeding at the same time. If you are going in the consumer court or a RERA, and if it appears that there is an offense committed by the builder, then you can file a criminal complaint against him in the police station. And if they don't register an FIR, then you have to file 156 subsection 3 in MM court and get a FIR registered. But you cannot have two civil remedies parallelly running together. So either one civil and one criminal simultaneously is fine.
My question is on section 15, which talks about transfer or assignment of the promoters right in the project. So at the company level, if there is a shareholding transfer, does the restriction under section 15 apply there?
No. If the company is remaining the same, right? If only the directors are changing, so it doesn't matter. Only if the company is giving their rights totally to any new, and the name of the company is changed, then the section 15 will come.
In case of the joint development agreement, can a landowner put a condition in the conveyance deed that for all the if the FSI increases in, let's say, future after 10 years or like that, the right over that the increased FSI will be belonging to the landowner itself. Is this conditional conveyance allowed, sir?
No, not allowed.
And another question, sir, the for the condominium, that is the association of allottees,
Yeah.
is there any criteria that such condominiums can be formed only in the metro cities, or are they allowed on the land developed on the Gram Panchayat area land, let's say in rural areas?
It can be formed anywhere. There is no restriction.
Achha, not necessary that it should be in the metro cities itself.
No, not at all. It is throughout all the state, it is same.
So for a project which was for which agreement was done on November 17, and date of execution, date of completion was mentioned as December 21. Now the builder says due to the pandemic, he is increasing the date, and he has got our RERA certificate that it has been extended to December 23. That is extension of 2 years. No consent has been taken from the allottees. Is it permissible?
No, not permissible. See, maximum he can have an extension of 1 year.
But RERA has given an extension of 2 years. From
So
December
you have to challenge it. Or better option is file a complaint in the consumer court.
Okay.
Date of possession was specified in the agreement
December 21.
December 21. So I would advise you file. And what is the valuation of the flat?
One flat is of 1.10 crores.
You are asking for a refund, or you want to have a compensation?
I want to continue in the project.
Then your case will come in the district court, because your claim will be around, say, 50 lakh rupees for the delayed possession and mental agony and harassment and other compensation. So it will come around 50 lakh rupees. So
Okay.
complain in district forum, first send him a notice and then go to the district forum.
Achha, consumer forum.
Consumer court. Yeah.
Okay. Now the builder has got approval from Pune Municipal Corporation for increasing number of floors from 13 to 16. He said this is also one of the reasons why the date has been extended. Is it permissible?
That's why I'm telling you that in such type of cases, you have to approach the consumer forum.
Okay. That I will do.
That's what I'm telling you, that you don't have to stick to the RERA only.
Okay, fine, sir.
Better chance and better rate of interest and good compensation in consumer forum.
Okay. So, one last question. As per your PPT, as soon as the sales of flats exceed 51%, he has to form a society or association. That he has not done. Almost 70% of the flats have been sold, but no association, no society has been formed. No WhatsApp group has been allowed to be formed.
So if you want to address that particular part, then go to the RERA, or else with the compensation and forming an society or association, you file both this thing in the state commission or district commission as per your pecuniary jurisdiction.
Okay, fine. And you asked about the cost of the flat 1.10. Actually, there are 2 flats, so the total cost will come to 2.2 crores.
Yeah, no. I'm just pecuniary jurisdiction will consider as per your claim amount. So what will be your claim? If it is
okay,
then it will go to the state commission.
Okay.
And if it is less than 50 lakhs, then it will go to the district forum.
Okay.
There was this peculiar judgment of the RERA where the division bench actually differed. So one of the members had opined that the act is actually applicable to the individuals who are getting permanent alternate accommodation. Now it has been referred to the chairman of the RERA. I'm not sure if it's not been very widely circulated, but are you aware of any particular standing?
No, I'm not aware of it, because I had also myself filed for the existing member, but the RERA doesn't come. In RERA, you don't have any remedy for the existing member.
Right. In a way, Section 3 actually ousts the jurisdiction.
Yes. So you should be an allottee. as per the RERA definition, that you should buy. See, suppose now I'll tell you, there is one thing which you can tweak.
Right.
That if you are going for a redevelopment, at least take 5 to 10 square feet additional from the developer and enter into a sale deed. Then you become an allottee automatically.
Right.
You're getting my
Right.
point?
Yes.
So
So
you want to come under RERA, but see, anyways, but remedy is available in consumer court also and in high court also. So I would prefer to go into consumer court or high court rather than go into RERA for the redevelopment of allottees, existing members. Because
Thank you.
that will give you, see, in consumer forum, you will not get only the interest, you will get the compensation for the mental harassment. For it means there are a lot of things for the misleading, these and that, unfair trade practice. There is a wide scope in consumer forum. And
Right, just
that is
that
taken at the same time like consumer court and any other court nowadays. So it is not that you are getting within 2, 3, 6 months. It's taking years and years now. So in such cases, you have to take a professional advice that where I should go. I should go to the RERA or I should go to the consumer court or I should go to the high court for the existing.
So my question is, RERA authority cross-verify the information submitted by the builders while registering the projects, and if yes, then how?
No, that is the very sad part of it.
So my next question is, what is monthly maintenance under RERA?
No. Then he will hand it over to the society. Na?
Okay.
Society
Thank
will do the maintenance.
Thank
See,
you, sir.
you watch this video again, so you will get, until and unless the land is handed over, the open space are handed over to the society, till then, developers' obligation to pay all the outstandings.
Sir, I wanted to know, being an old tenant, a client states that he wants to buy an additional area from the builder of, say, 35 square feet area. So basically, he's getting a new carpet area of 750 square feet and he wants to get 35 square feet more. So for that, will he execute, will it be included in the permanent alternate accommodation, or would there be a different sale deed for the additional area?
He is paying the money to the builder, na?
Yes, he will be paying an amount of 10 lakh for the remainder area. So say 750 plus 35.
On that 10 lakh rupees, he'll have to pay stamp duty.
That's correct.
And plus he has to go for the registration. So PAAA plus for the additional area, there has to be a separate agreement.
Okay, so there cannot be, it cannot be integrated in the PAA, right?
It depends. If he wants, he can integrate it, but the sale deed is much better for that additional area, so that you become an allottee. If you want to go to the RERA also, that will help you.
Our builder is insolvent. They formed the company and now it's insolvent. So should we register? That case of NCLT is going on. Other owner has registered in the NCLT. So shall I go for 156(3) in a criminal code?
You should for 156(3), that is for the criminal proceedings. But what you should do is you should become an intervening party in NCLT, and you should cancel his registration under Section 7, and under Section 8, you should take over the project and try to complete it yourself if the builder is insolvent. So what is the stage of construction right now? What will be the cost of completing the remaining, and what are the unsold inventories where you can sell it and recover the money? So your money is safe when you take over the project from the builder under Section 8.
And secondly, he has taken a loan from PNB. Because of that, he is insolvent. Means he will not complete the project and he's diverted.
Where is the project?
It's at Oshura.
So there are unsold inventories also.
Yeah.
So what you do is, if I can go through that and I can suggest you some remedies.
Yes, sir.
So it's better to take over the project rather than, just go on filing the complaint, because it is not going to help you. If he goes inside the jail also, your money is going to stuck. Now, what we have to look forward is that how we should take over the project, complete it. So at least if you're not getting any profit right now, but once the project is completed, the value of that property will be enhanced and your money will be recovered.
Yes, sir.
So that is the whole idea. It should be not just filing cases and criminal cases and you get nothing out of it and then you get frustrated in the end. So it is
Yes,
to look out for a solution out of the box. For me, right now, without seeing the document, I'll say that you should take over the project. But that I can say only when I see your documents, I can guide you that how you should take over the project and complete it.
Sir, my query was regarding the questions which other people have asked. Like in one of the cases, you said that if someone is buying additional square feet, like if PAAA plus if someone is buying something more over it, then he's assigning a separate registered document for it, paying the stamp duty. Then he is also included. He can go to RERA, right?
He comes under the definition of allottee and he can file a complaint in RERA.
That building might not be registered because if builder is making two separate buildings, one for the tenants and one for the new buyers, then in that case, the old building, like usually the RERA registration is common for both the buildings or it is separate for saleable building as well as?
It will be separate. But once he is selling it, so what you do is you will have to see what is the provision in the RERA. If he's selling units more than 8 in your building, in your rehab, right? If there are 8 units, he is selling it more than 8, then he has to definitely go in registration for the RERA.
Even if it is a tenant building.
But he's converting into an ownership, no?
Yeah, right.
So if he's selling 8 different agreements are been more than 8, say 9 agreements.
Selling as such, saleable selling or PAAA?
I'm talking about the existing members.
So if there are more than 8 members,
more than 8 units which he's selling, whether it is 100 square feet, it doesn't matter. But if it is more than 8 units, then he has to go for RERA registration. That is one thing. And then you don't bother about whether you should fit in the RERA allottee or not. What you should look for is, if you are an existing member, then you have a consumer forum available to you, and plus you have the high court availability. So don't have a mental block that मेरे अभी RERA में नहीं है तो मेरे पास कोई provision नहीं है. RERA initially बहुत अच्छा था. I was also very happy because the judgments were, within 15 days to 2 months, then 6 months. Now it is taking years. Sometimes it is taking more than what the consumer forum or district, the state commission is taking.
Okay.
It doesn't make any difference to you. So don't be disheartened that whether you don't fit in the RERA or not. But you have definitely your remedy is available in the consumer forum, the consumer fora, or in the High Court.
Like you said, if we are paying more than 10% of the amount, instead of agreement for sale, we can also go for sale date. Was it?
So that's what I told you. The moment, suppose if the consideration value of that flat is 1 crore rupees, for example, as in for allotment letter, he has taken 10 lakh rupees from you, right? So that is a 10%, till 10% he can take money on allotment letter. The moment that 10% threshold is crossed, even if he's asking 100 rupees more, then he is bound to register the sale deed.
Sir, then there are many people who say sale deed is executed after the payment has been fully paid, like there is no balance and zero due. So what?
No.
That is a different thing.
I don't have such any information. Normally, what we do is that the moment the threshold cross of the 10%, then immediately we go for a registration of the sale deed.
One person was asking regarding the maintenance for the builders, like is there any norms or provisions in the RERA Act? So sir, my query was, many a times when it is still to be handed over to the society or society is not yet formed and the builder has their own amount, like we have to pay for coming 12 months or coming 24 months, they fix an amount which we are supposed to pay them. Whether the amount is legitimate or whether it is over the nominal rates tend to is there any norms under which we can ask that why are you charging so high rates for the maintenance?
Yes, there are. In the RERA Act, in the MOFA, everything is there. See, till the land is conveyed to the society, it is builder's obligation to pay all the outstandings, like property tax and everything. But you exercise your right and you go as per the builder says, but you have the right available. Till the land is conveyed in the name of the society, it is the obligation of the builder to pay all the outgoings.
the definition of allottee, it says that, if I may be allowed to read, allottee in relation to a real estate project means the person to whom a plot, apartment, or building, as the case may be, has been allotted, sold, whether as freehold or leasehold, or otherwise transferred by the promoter, and includes the person who subsequently acquires the said allotment through sale, transfer, or otherwise, but does not include a person to whom such plot, apartment, or building, as the case may be, is given on rent. Now, a building is constructed only for the purpose of renting it out. Why is freehold and leasehold included as sold in the definition of allottee? How do I distinguish between a rent apartment, or rather a building constructed merely for the purpose of tenancy, and an apartment which is constructed for the purpose of selling it? My question is that
if it is constructed for the tenancy purpose, you mean to say the pagdi system?
Yes. Would that be?
There's the question of RERA coming into the picture.
But it includes freehold and leasehold.
See, in Mumbai, there are several lands which are freehold and which are leasehold. Leasehold are the lands where the collector is collecting the lease. But the lease is given for 99 years, 999 years, or perpetual lease.
Right.
You have to pay that lease of that plot. The society is paying that lease rent to the collector.
Right.
So that doesn't come under the tenanted property. Tenanted property, if suppose I am constructing a building and I am going to give it on rent, so where is the question of that allottee coming into the picture? Because he's not an allottee, he's not a tenant.
Right.
There's a remedy in the Mumbai Rent Act.
How will somebody find out whether today the developers have constructed this building for the purpose of rent? Tomorrow they'll convert it into ownership. Who will keep a track? Now, how does RERA?
No, but suppose if tomorrow he's selling it as an ownership, then the person who is purchasing will become an allottee.
If, say, out of 10 apartments, if I'm only giving one for ownership and the remaining 9 stay for rental,
then he cannot give one for ownership and 9 for pagdi system. And if he's giving one for ownership also, he's not selling more than 8 units.
That's right.
He doesn't have to register under RERA.
Right. So out of the 10
registration will come if he's selling more than 8 units or if the area of the plot is more than 500 square meters. Right? Then only the RERA will come. If I am constructing a building and I just want to give it on rent, I want to give the flats on rent to the corporates or to the individual members. So where does the person who is entering into my leave license agreement will fit into the allottee of RERA? No.
Now, sir, in a scenario where, say, there are 16 apartments, of which 8 are given on rent and 8 are for ownership. Therefore,
so
the people...
Then also the RERA doesn't apply because more than 8 only he has to go for the RERA registration.
Let us consider 9 in that case. My question is that...
then yes, the 9 people will become come under the definition of allottee and the project has to be registered with the RERA.
All right. So basically, for rental purposes...
Only the 9 people will be recognized as an allottee by the RERA and not other 8 people who are staying on rent.
So only those 9 will have the remedy under RERA, whereas the other 9 will have to go for consumer forum.
No, see, if they are in the pagdi system, the consumer court is also not going to help them. Then only the Rent Control Act will come into the...
Right, sir. So just recapitulating that rental agreements are not covered under RERA, no matter for how long, because there's a very thin line difference between rent and...
No. See, rental agreements don't come under RERA. Controlled by the Rent Control Act. They come under the ambit of Rent Control Act.
For a building of 280 square meter of land, where the CC allowed is for the 4 floors and the total blocks or flats are, let's say, 12. And it's a JDA for which owner is getting 50% and the builder is 50%. So 6 flats will be for the owner, 6 flats will be for the builder, and builder sells all the 6 flats and the owner is not selling at all any flats. Then still the society can be formed or no, sir?
Society can be formed. You can have a provision for a society.
So it's not necessary that all the flats should be sold.
Then
to the
he will have
individual.
only one voting right.
Okay.
Listen, there will be 7 members.
7.
Who have purchased and 1 member will be he. The certificate will be issued all in his name only. He will have only 1 voting right. If he changes the name, that one brother's name, one is his wife name, one is the daughter name, then everyone will become a member in the society. But if he's keeping on his one name, then only he will have only one voting right.
Even though only the 7 individual names are there, then also society can be formed. Huh?
Yes, yes.
And instead of this, condominium can also be formed, sir?
Yeah, you can have an association also.
So what do you suggest for the landowner's view? Condominiums are better or society is better, sir? Any suggestion?
He's cooperating?
Yeah, he is cooperating.
Cooperating. Then he should cooperate with the formation of society. Then society is much better.
Sir, can an advocate and agent can be a same person?
Advocate cannot become an agent. He has to surrender his sanat.
Hello, sir. You just mentioned about the membership rules. I had a small query on that, just off the topic. My father has 2 flats in the society. For one, he's attending the meeting, and for other flat, can I attend as an associate member for that flat? Can both the people attend the meeting and vote on the redevelopment thing?
Yeah, then you have to complete the formalities.
Yeah, because at the meeting, the people told me that because a member is attending for one flat and he owns both the flats, so I cannot attend as associate member for other flat.
No, but have you applied for associate member?
Yeah.
When you have applied?
More than 5 months ago, and I didn't receive any reply. So I presume I am a
so you have to approach the deputy registrar for any application of membership, whether it is associate member or a regular membership or a nominal membership. If you don't receive any objection within 90 days of the application, then you become a deemed member of that society, whether it is deemed member or deemed associate member. What you have to do is, with the same application, you have to go to the deputy registrar that kindly direct the society to make me a member. Automatically, you in the deemed membership will become a member because they have not written you in officially anything writing objecting it, right?
Yeah, not received anything officially.
You have not received anything. So immediately apply to the deputy registrar.
And without this process, can I attend the meeting? Can I claim I am a deemed member?
You can claim, you say that I have applied and you show the provision of the MCS Act that within 90 days you have not objected or not send me any objection in writing. I become a deemed member and before that you file one application and then you attend the meeting.
Okay, thank you.
File the application in the deputy registrar. So you have you can say that my application is pending there. I am a deemed member already because within 90 days, you have not replied to me. You have not taken any objection. So now you cannot object me that as an associate member, I cannot attend the meeting.
In case of an association, there was a fire in B ward. Government allotted the land to the association that you shift from B ward to Vadala and construct the godown there instead of in B ward. Now the association will be constructing the godowns and allotting to the members. They will not be selling to any other outsider, only to the members only, out on the plot which is given by the government. In this case, whether the association is required to be registered under RERA.
They are not selling it, no?
Not selling.
So it is not required. And how many units are there?
Units will be more than 400. 400.
So it is only shifting from one place to another?
Those who are in B ward only and some other traders, they will be given.
So they will be shifted from B ward to the, say, Vadala terminal or
and they should be member of the association only.
Right. So it is just you are shifting from one land to another. You are not selling. So you don't.
But the land was independent. Here they are purchased. Here they are actually allotting, and they will be paying the contribution of the construction costs.
That is fine. But there is no need if there is a sale which is going to take place. If you are going to advertise and you are going to sell the units, and if the units are more than 8 numbers, or if plot is more than 500 square meters, and there is advertisement and you are going to sell it, then you are under RERA. If you don't do any of these things, then there is no need of registering under RERA.
In a redeveloped project, land is not conveyed to the society, but BMC has sent notice to members for property tax, and members were forced to pay. Builder paid till 2017. What is the remedy?
Remedy is available in the consumer court. So land is not conveyed, so you will be compensated for that also, and the consumer court will give an order that the conveyance has to be done.
So before we close, just like you created a lot of awareness amongst the lawyers, and there were a lot of buyers also. So any message for a potential buyer? Like how can a buyer be more proactive?
See, normally what happens, when they go to the builder's office, the builders create such an excitement and such an scene of emergency, right? आज तुम टोकन दे दो तो तुम्हारे को 2 लाख रुपए का हम डिस्काउंट दे देंगे. सो बोले टोकन नहीं है तो व्हाट दे से इज आप गूगल पे कर दो, आप ऑनलाइन ट्रांसफर कर दो. सो वो टाइम पे जो माइंड का जो रीजनेबल थिंकिंग है वो ब्लॉक हो जाता है, बिकॉज सेल्स टीम आर सच एन पावरफुल लाइक LIC एजेंट्स, राइट? They will come and sell you the policy which is not required for you because of the commission. So even the sales team in the builder's office, they are trained in such a way that you have to create a situation of, excitement and emergency to the home buyer that he closes the deal today itself. The moment you apart with 50,000, 1 lakh or 2 lakh, I've seen one of my client who had swiped 10 lakh rupees of credit card to purchase, to do the booking. And then he realized that he was in a trap. So don't take decision in a haste. Check the credentials of the builder, how many projects he has completed in the past. If they are delayed by 6 months, 12 months, according to me, they are a good builder. But if the builder is having all the stalled projects for years together, so kindly avoid that builder. Do the due diligence. And what happens when you are parting your money, 1 crore, 1.5 crore, 2 crore rupees, then take a professional advice. Go to an advocate who is expert in this matter, pay his fees, 5,000, 10,000, whatever his fees is there. Try to understand that all the title certificate which are uploaded on the RERA website, the CC, the agreement is as per the RERA or not, and then only take the decision. Don't take the decision in the haste just because the sales team wants to complete their project, and you shobe the scapegoat or the what you call the punching bag.